My Lords, in this case, according to the second amended petition, the petitioners are essentially asking your lordships not to let the votes of some 5 million citizens of Ghana in the 2012 elections count. The petitioners are further asking that you set aside the declaration that was made by the chairman of the Electoral Commission on 9th December that President John Dramani Mahama, the first respondent, won the elections. And they go on to ask you, after you agree to the attempt not to let almost 5 million votes count, they ask you to accept a new computation that they have made of results, whereby the first petitioner becomes the victor of the elections. And they ask your lordships to make a declaration accordingly, substituting for the declaration that was made on the 9th of December. These are the stark claims that the petitioners are making before you. In asking that you not let those almost 5 million votes count, they admit that none of those voters did anything wrong. They also admit that no one voted more than once. They are not claiming that anyone who was not registered to vote, voted. They also admit that President John Dramani Mahama did nothing wrong. Yet, the petitioners say to you, do not let the vote of so many millions who cast their vote for President Mahama count, and also do not let fewer millions that voted for the first petitioner, don't let their votes count either. And then you will end up with the results that they desire. So effectively, my lords, the petitioners are asking you to impose a retroactive penalty on people who stood in line for hours and cast their votes. The votes were counted as valid votes, and they are now asking your lordships to annul those votes retroactively, effectively. Now, the Constitution of the Republic is very clear in terms of not countenancing such retroactive penalization in our respectful submission. Not only because of the clarity with which the right to vote is expressed in the Constitution, in Article 42, a matter on which your lordships have ruled and have expounded very clear principles, but also because even in respect of criminalization, Article 19(5) of the Constitution does not allow the imposition of such retroactive penalties. And our submission is that effectively what the petitioners are asking you to do is in the nature of that kind of penalization. But my lords, in this case also, faced with the need for evidence to be provided to discharge the burden of proof that lies on them, the witness of the petitioners essentially disqualifies himself from being able to give credible testimony. He said, you and I were not there and all that. Basically, under the terms of the evidence laws of this country, somebody who lacks personal knowledge of the issues in controversy has no capacity whatsoever to give testimony that your lordships can rely on to make the kinds of declarations that that person is seeking. And my lords, this witness actually let his side down also in fundamental respect. This witness claimed, and he repeated it in testimony, that the documentary evidence that he was providing was in respect of the 11,842 polling stations, in respect of which, according to him at the time of his testimony, they were now seeking to have the annulment made. In his affidavit, he insisted that there were 11,842 spread into 24 categories, according to paragraphs 44 to 67. And he then gave votes in respect of each category for annulment. So basically, my lords, 11,842 polling stations is what we were entitled to expect. And he insisted in cross-examination that these were the polling stations reflected in the pink sheets that he had provided. So he repeated this in the affidavit on oath and in the witness box on oath as well. Now, my lords, this claim proved to be false. It proved to be false eventually because your lordships ordered a referee to take account of the pink sheets that have been provided and to determine the number of polling stations in respect of which these pink sheets had been provided. The count was clear. The evidence of the representative of the referee, KPMG, came out clearly. The number of polling stations reflected was no more than 8,675, a far cry from what was alleged by this witness. Clearly not a truthful witness. My lord, so we moved from a situation where 11,916 had been alleged in a second amended petition to 11,842 in his affidavit, and then come cross-examination, my lord, that number began to go down further. The witness said he was deleting first 83, then later a list of 704 polling stations got out, so he was left with 11,131 or something. Then, my lord, this process actually continued because what we now have in the closing address of the petitioners, and respectfully, my lord, this is the closing address of the petitioner, where we now have a claim, not in respect of 11,100 and whatever, but now it is 10,119 polling stations. Before that, on the last day but one of cross-examination of counsel for the petitioners in respect of Dr. Farijan, he had given yet a different number, 10,081 polling stations. Well, these shifting sands cannot be a basis for your lordships properly to accept that petitioners are giving you a basis in evidence for what they are seeking in their petition. Now, my lord, the matter gets even more serious because even within these 10,000, as they now allege, we have shown clearly that you cannot even depend on those kinds of numbers for testimony. Because, my lord, within this 10,000, on the face of it, there are exhibits that are outside the range of the affidavit of Dr. Baumia, and Appendix E4 of the KPMG report lists 339 polling stations in respect of which we are talking about outside the range in the P series alone. 339 polling stations are immediately ineligible for any use by your lordships, just on the basis that the affidavit of Dr. Bawumia says P series, MVP1, MVP, and then MVP1 to 6822. And then you find exhibits that go above 7,000. Now, my lords, those clearly are not meant to be evidence in support of any of the claims in the affidavit. But, my lords, the matter is not only related to the P series. There are other ranges, as the KPMG series report shows, other ranges, particularly the K and the H, in respect of which also there are respectively 13 and 12 exhibits that are outside the range, which means that another 25 polling stations are ineligible for your consideration. But, my lord, in their address, this confusion is further compounded, because in their address, my lords, we have exhibit ranges such as the K range, which according to the affidavit of Dr. Bawumia should end at K70. We have them suddenly going up to K700. The affidavit says to your lordships that I am providing polling stations that have pink sheets that are numbered K1 to 70. These support my case. These are the polling stations in respect of which I'm asking your lordships to annul votes. And then suddenly, at time of closing address, we now have K700. Now, my lords, you cannot respectfully, at this stage, be requested to use as evidence matters that clearly contradict their own affidavit. And this goes on further because, my lords, we find that in the P series, and this was indicated in cross-examination of Ne Amano Dudu, we find that in the P series, and my lord, this is Appendix 1, this is indicated in Appendix 1 that is attached to our written submissions. In the P series, we have 2,120 exhibits which basically do not make sense. 1,060 of them have an exhibit number with certain polling stations named. The other 1,060 have another, they have the same exhibit number, but another set of polling stations. Your lordships are not respectfully in a position to choose for the petitioners which set with the same exhibit number, which set of those exhibits they really want you to rely on, because essentially they cancel each other out. That's 2,120, and we have attached those to our written submissions. My lords, in addition, the rules of this court are very clear, and the rules of this court, as reflected in Regulation 68A, Subregulation 2, provide that the petitioner shall provide not less than 7 copies of the petition for use of the justices of the court and for service on all the respondents and on the Electoral Commission, unless the Electoral Commission is the respondent in the proceedings. My lords, the KPMG report is clear. In respect of many instances in the P series, they have not even provided that 7, or they have not, in some cases they provide 1. And so, my lords, respectfully, we are submitting that those 1,725 polling stations that are reflected in our Appendix 1A to our written address, those 1,725 are also unavailable as testimony testimony of any sort in this case, because, my lords, those exhibits were filed in a single set and they still remained in the custody of the registry. Clearly, they had not been made available to the respondents, and they certainly have not been made available to your lordships, and they cannot be made available to your lordships. And my lords, respectfully, we also have the situation, which we indicate in our written address, where 93 of their exhibits are not within the further and better particulars. So all these exhibits, and respectfully, if you add their own deleted stations, deleted polling stations, we're talking about more than 5,000 of this 8,675 count, which are simply unavailable as evidence. And my lord, this is not respectfully just a matter of some technicality of not following regulation 68A in terms of the number of documents that you file. This respectfully goes to the heart of the issue. What is the case that is being presented in order for the court to adjudicate on? That case cannot be presented to your lordships if these regulations in respect of what is filed in support of the case, if they are not reflected in what the KPMG referee has established. My lords, we submit therefore that the petitioners have not even discharged the evidential burden, not even the burden of persuasion. The evidential burden has not been discharged. So we are not even at a stage where evidence has been produced to your lordships that will enable your lordships to begin to consider the claims that they are making. My lords, the nature of the claims that we are making, we also submit, fail in terms of just basic legal clarity as regards what they are claiming. The claims of overvoting are based, according to them, on the right to vote. And one man, one vote. That is indeed the right to vote. But, my lords, no evidence has been brought before you that establishes that claim. Not only that, but we respectfully submit that in respect of that claim, the evidence of Dr. Baumia himself was very significant. Dr. Baumia himself acknowledged, reluctantly, but he eventually acknowledged that you cannot just take the pink sheet and the interpretation that they started with in order to come to that conclusion. He acknowledged, for instance, that they have failed to consider proxy votes, and therefore in the witness box he acknowledged that the proxy votes reflected in those pink sheets should be taken account. He acknowledged that on some pink sheets there was not enough information. He claimed in some cases that where there's a blank, it means zero. Now, your lordships certainly would be hard put, in my respectful submission, to accepting such a claim, that a blank in a form means zero. And we respectfully submit that with all the admissions that he himself made, his constant refrain that the analysis remains the same cannot be truthful. It cannot be truthful simply because if you delete polling stations, if you delete certain claims that you have made earlier, you cannot have the same numbers, especially if you do not substitute something in place of those that you've deleted. So, my lords, based on the admissions of Dr. Baumia alone in respect of this category, where many times he acknowledged that the claim could not hold after he himself did his calculations in the witness box, it is clear that that basis does not exist. Now, my lords, in respect of the claim of voting without biometric verification, I respectfully associate myself with the submissions that have been made earlier. In respect of this, also, it is quite clear that they fail to make their case. My lords, in respect of the absence of the signature of a presiding officer, again, we respectfully invite your lordships to notice that Article 49(2) of the Constitution, on which they place so much reliance, that article Article 49(3) is the most pertinent, but before that, Article 49(2) reads, immediately after the close of poll, the presiding officer shall, in the presence of such of the candidates or their representatives and their polling agents as are present, to proceed to count at the polling station the ballot papers and so on. So, my lords, the role of the polling agents in respect of the counting process, and it goes on in 3, the presiding officer, the candidates or their representatives, and in the case of referendum parties contesting or their agents and the polling agents, if any, shall then sign a declaration stating A, the polling station, and B, the number of votes cast in favor of each candidate, and the presiding officer shall then announce the results of the voting at the polling station. Now, my lords, it is not only the presiding officer who is required to sign. The polling agents also, if they are present, are required to sign. And it cannot respectfully be submitted that a failure of a public duty entitles anyone to nullify votes of innocent voters who could not have anticipated that that public official would not do his duty. Now, my lords, the petitioners actually try to have one of such presiding officers testify to an affidavit, and we bow to the superior wisdom of your lordship in not allowing that person to be given the platform of this court to come and waive their failure of public duty in the face of the public. And we submit respectfully that nowhere in the Constitution is it provided that that failure of public duty should lead to an annulment of the votes of people who had done nothing wrong and who did not in any way expect that that public official would do anything wrong. My lords, I respectfully also invite your lordships to note that both in that Article 49(3) and in the CI 75 Regulation 36, the matters in respect of which there is an obligation on the presiding officer to testify and to have the polling agents attest is in respect of the results, the counting of votes. Those are the matters dealt with there. The ballot accounting part is relevant, but it is not one of the matters in respect of which the Constitution or the constitutional instrument make provision. And you cannot, through your interpretation of that ballot accounting portion, seek to nullify the impact of the votes that were attested. Effectively, those votes were acknowledged on the face of the pink sheets themselves to be valid votes and counted as such. And they cannot now retroactively be discounted. My lord, the most outrageous claim of the petitioners is in respect of serial numbers. As counsel for the second respondent has expressed it, it is the weakest link in an already weak chain. And my lord, that claim really is not borne out by any legislation, not borne out by any constitutional formulation. But my lords will notice that that claim is the basis on which over 3 million votes are being sought to be annulled. It is a claim that Dr. Baumia admitted he didn't know of the law, any law under which it was being made. And, my lords, that claim is actually not just the weakest link, but it also appears to be the Achilles heel of this whole petition. Because, my lord, it is in that category of the claim that we find this incredible attempt to bring up more and more polling stations, ending up in the confusion of exhibits that we have indicated previously. Because as they threw in more and more exhibits in a jumble, they could not even tell that the exhibits were contradicting each other. They could not tell that the exhibits were not even being supplied according to the rules of the court. And they ended up, my lords, with those almost 4,000 that are in our appendices 1 and 1A, which your lordship simply cannot have any use for. My lords, it is also pertinent to indicate that the petitioners made it quite clear, especially in Dr. Baumia's evidence, that their whole investigation was in regard to 24,000 polling stations. Not the 26,002 polling stations in this country. Their whole investigation was tied to 24,000. Respectfully, my lords, you cannot be asked to make a declaration such as they seek based on evidence related to 24,000 polling stations, not 26,002. Especially, my lords, when what they have eventually brought reflects selectively what they find favorable to them. Even if your lordships were to decide, for instance, that blank means 0 on pink sheets, your lordships will respectfully then have to have the whole universe of 26,000 pink sheets inspected in order to determine wherever blank is, blank means 0. If that was to be your lordship's decision, that would be the nature of what would happen, what would have to happen. So, respectfully, my lords, we believe that this petition has been shown to be factually empty in terms of not having any supportable evidence being produced. It has been shown to be legally pathetic because the claims that are being made have no legal standing whatsoever, especially this claim about serial numbers. The petition has also been shown to be poor in arithmetic because you cannot have the same numbers when you're reducing polling stations, and certainly extremely poor in logic, and we might add deficient in statistics as well.